Hello, and welcome to the MeyerSuozzi podcast, a series of discussions from our successful attorneys giving innovative and creative insights on some of today's legal challenges.
Hi, I'm Paul Millus. I'm a partner in the firm of Meyer, Suozzi, English & Klein, and a member of its employment and commercial litigation sections. I'm here to talk about employment terminations today. Before we start, a little disclaimer. This is not meant to provide legal advice. Legal advice is provided in a confidential setting between an attorney and a client, where the client can provide relevant information to the attorney can assess it, and make a determination as to what's in the best interest of the client. Rather, we're going to talk in general terms today about employee termination. Now, I'll tell you what we're not going to talk about. We're not going to talk about mass layoffs or RIFS. There are particular concerns that go along with engaging in a mass layoff or RIF. Nor are we going to talk about terminating a union employee. That's generally subject to the terms and conditions set forth in a collective bargaining agreement. That document will be your guide. And that also is above and beyond what we're going to discuss today. Finally, we're not going to talk about termination of an employee in a civil service setting. Having done some municipal work in the past, it is no easy task to properly terminate a civil servant. Rather, what we're going to discuss is a small or mid-sized company in particular that may not have the protocols and procedures in place, but knows that an employee has to go for one reason or another, generally and truly for the benefit of the company. Let's start with a principle. New York is an at-will employment state. You can fire an employee for any reason or no reason at all, provided it is not an unlawful reason. And I think every employer is familiar with what would be an unlawful reason. Firing someone because of their race, their gender, their age, their disability, their sexual orientation, and some others is forbidden under the law. But if you want to make a decision to terminate an employee, it's a process, and a process that you should study and be prepared to implement to the T, consistently, no matter who the employee is. When you treat employees differently, in any way, shape, or form, employees can use that as an excuse to say, I was treated differently because of my age, because of my gender, because of my national origin, race, or whatever it may be. It may be wholly untrue, but you get yourself into a problem if you don't do it right. So, let me tell you a little bit about statistics. In 2020, there were 64,448 charges filed before the EEOC. The prior year, there were 72,675. So at first blush, one may think that's a decrease, and it is in the numbers, but of course people weren't at work for 9 months out of the year. And yet you saw 67,000 charges filed. And let me tell you, not everyone files with the EEOC. In fact, in New York State, under either New York State or New York City law, you're far better off not going the federal route and filing your case in state court under the New York State human rights law. So we're talking about a lot of claims and a lot of litigation. And that's something you want to avoid. You want to avoid having to contact me with a problem that's arisen because you didn't follow a process or because your process was inconsistent. So therefore, let's talk about what the considerations are. First, you have the pre-consideration in any employment termination. Why are you doing it? Are you doing it to further the interests of the company? I should surely hope so. And who are you doing it to? Are you doing it to a person who may be able to claim some form of discrimination? Let's face it, folks, we live in a litigious society. That's a fact. There is no shortage of plaintiffs' lawyers out there to take on a case and to claim, maybe without merit at all, that a person was fired because of the color of their skin, their age, or their sexual orientation. So the fact is, you need to look at who you are terminating. And you want to dot I's and cross T's on every termination, trust me. but certainly if you have a person who falls into one of those classes that are protected under Title VII, that are protected under New York State human rights law, just pay special attention and make sure you do it right. So if, let's say, you're terminating somebody on an immediate basis, an employee comes in and causes harm to another employee, physical violence in the workplace is never acceptable. That employee could be terminated on the spot and should be under those circumstances. And then you'll deal with the post-termination considerations, which we'll discuss and are equally the same. But most times, an employment termination decision is made after some meaningful review of that employee's performance in the workplace, whether that employee was getting their job done or not. And how long did that take place? Pre-considerations. If you have a review process in place, pull out your reviews. If the reviews are glowing for a period of time prior to the period for which you want to make the termination decision, maybe you should ask yourself why. And under what circumstances did the performance then fall off? Because that employee had been told on numerous occasions that they were doing a good job. So when they're terminated, they wonder, how could it be me? It must be something else. And that something else can be capitalized upon by a plaintiff's attorney in a potential claim filed before the New York State Division of Human Rights, the EEOC, or a lawsuit outright. Now, when dealing with an employee who has performed poorly, honesty is the best policy. Make sure from the get-go that your supervisors know to be clear and concise as to when an employee is not performing their job. Because if you sugarcoat it, because you don't want to hurt the employee's feelings, then the record that you're making is that the employee is doing a good job, even though that's untrue. We'll get to that in a little bit in terms of what you tell the employee during the termination process. So, we've thought about this. Now we have to figure out how we're going to implement it. We've come to the conclusion that the employee, albeit may claim to be fired for other reasons, is really being fired absolutely for poor performance. And the company has a right to have employees perform properly. So how do we do it? What are the considerations there? Who's going to be present? Who's going to announce this to the employee, and how is it going to be announced? Now, my advice generally is to employers is to always have two people present during an employment termination. Why? Have someone who could back up exactly what was said. Because it is an emotional setting. It is a bad day for that employee. And if that employee is not willing to accept the reality that they were performing poorly, but rather is being fired in their mind for some other unlawful reason, things can be said that they could try to use their advantage. So have two people present. And when they go in, they should have a script. Should make it clear to the employee the reason for why they are there. The employer performing the termination should be clear and concise as to why the employee is being terminated. Again, so important. I have had situations where employers didn't want to hurt the employee's feeling and basically came up with, it's not you, it's me, which is a horrible thing to explain to the employee when it's untrue. It's unfair to the employee, and it's certainly unfair to the employer. Because later on, when the employee brings a lawsuit and says, this is what I was told, I was not told that I was doing a bad job. In fact, they told me they liked the job that they were doing, but they had to cut back for some financial considerations. And assuming the evidence doesn't bear that out, that the company was doing quite well, one could lead to the conclusion that the employment termination was taking place for an unlawful reason, assuming that individual falls within a particular class of employees. Honesty is the best policy. You must make it clear to the employee that this is not a situation where the decision is going to be changed. That's something that you don't want to negotiate. If you're going to go through this process and have an employee terminated, don't backtrack, don't waffle. There may be tears. Try to be understanding. Try to be human when dealing with this, because it's a bad day for that employee, and hopefully they'll appreciate that. But be clear, be concise, and don't backtrack at all. Now, once you've announced this to the employee, what are the postscripts? What are the next steps? Under New York law, you have to provide the employee with a written explanation as to the fact that they were terminated and what their effective termination date was. And that's within 5 days of the date of termination. That's something you have to do for all employees. But what do you do in terms of last paycheck? Again, under New York law, the paycheck has to be made by the next pay period that the employee was employed. Don't fall victim to an administrative mistake on simple things. There's a $5,000 penalty for failure to do this, and if you do this with multiple employees, the state and the city that have their rules are going to want to capitalize on it. People will make complaints. You will get a call from New York State Department of Labor, and they will be looking for you to pay a fine or penalty. So don't fall into that trap. Make sure you're ready to do so. You have to also provide a COBRA notice. You should look to the present status of the law because it's ever changing. Now, in New York State, the employer is required to pay 6 months of COBRA benefits for an employee. That didn't exist before. So consult with your counsel, consult with your human resources professional. Make sure that you provide the COBRA notice to that individual, because an employee has a right to COBRA, assuming that you have a medical plan in place. Now, what are the other considerations? What do you need to do in terms of employee access? Well, the simple answer is you need to cut it off completely, utterly. Passwords need to be changed. Email accounts need to be closed. And quite frankly, you should secure all the emails that your employee has sent during the time of their employment. Have them put someplace. Put into another station, some other holding device, because you know what? You never know if you might need them or not. And today we can store gigabytes of material at low cost. So secure that individual's computer. Secure any emails and communications on it, just in case you need it in the future. You don't want to repurpose the computer without shadowing the hard drive. That's always my recommendation. It costs a few dollars, but if there were communications or things being done which somehow supported your termination decision or the employee's performance in the workplace, you want to have that available just in case it comes up. You want to take away all security badges immediately. You want to tell the security of the building, assuming you have it, that this employee is no longer employed. You don't have to say they were terminated. You don't have to give a reason. But you want to let them know that the person no longer is employed and should not be provided access. Is that foolproof? Absolutely not. They don't work for you. So getting them to be your security firm is impossible. But it's something under the circumstances. Look, 99.9% of terminations result in nothing in terms of potential violence. But we all see what happens on the news. We see the disgruntled employee coming back to the workplace and taking some sort of horrifying action. Again, 99.9% of the time, it doesn't happen. So therefore, I'm not telling you to employ security. I'm not telling you to call the police if you see the person on the premises, but have a watchful eye. Let your employees know that the individual is no longer working with the company, Only those who are in a direct line of supervision should really know the rationale for it. The rest of them, just simply let them know they're no longer there. If that person is seen on the premises, having no reason to be there, they should let you know, just in case there's an issue that could arise with that employee. Again, I think you'll have a feel for that. I think that those employees who left their employment and came back and did some harm probably gave some telltale signs. Watch for them and address them as you need to do. Once you're done all of these things, you have put yourself in the best position to prevent yourself from being sued by that employee in some claim going forward. There are other considerations, and again, in consultation with an attorney, if needed, and if you feel that issues may arise with that particular employee, you will learn the things that you should make sure that you do in order to better protect yourself going forward. Again, people can sue for any reason at any time, much like New York State is an employment at will state. But it doesn't mean that they have to. It doesn't mean that they're going to win. It doesn't mean that you have to pay in settlement or a judgment in connection with that employee's claims. Do the smart things going in, and if you do, you'll find yourself to be in the best position possible to protect yourself. I want to thank you for the time that you've given me today. I hope you've enjoyed this podcast. We'll have future podcasts in other areas of the law that I hope you'll find enjoyable as well. Good afternoon.